wait till you're ready.
Okay.
Great.
Hi. Hello, everyone. Thank you for joining DataCon LA 2020. Welcome to the Data Infrastructure and Security track. And soon we'll be listening to cybersecurity, privacy, and data security from a business lawyer's perspective. Her name is Kathy Winger. My name is Priya Chauhan. The host is Bob Neustadt, and we'll be moderating the question and answer for this session. Kathy's presentation includes a discussion of data breach cases and takeaways from those cases that no companies, large, medium, small, are immune from liability. She discusses the potential impact of data breach on a business and the steps for businesses to take to protect themselves from the timeline of the breach before, after, and during. Kathy discusses FTC role in the regulation and enforcement of actions related to data security and data breaches, and talk about commercially reasonable standard that FTC applies to determine liability. By the way, I do not know what that is. This FYI, what the standards meant from a legal perspective are, and how relative it is, how it relates to data security and measures cyber insurance. Without further ado, I'm going to transfer it to Kathy Winger, and we welcome you to DataCon 2020.
Thank you so much. And I hit the share screen and pulled my PowerPoint slideshow up. Can someone just tell me if you can see it?
No, I see your beautiful face.
Oh gosh, okay. Well, I would like you to see my slides. So I'm wondering, I'm going to try and share again.
Okay.
And let's see if I do that. Now, let me see. Now, can you see them?
Yes, I
You got
do.
them. Okay, great. And you
Beautiful.
saw my adorable son right before that, I think.
Yeah, I did. Beautiful.
Screensaver. Well, he's now in his second year at West, or his third year at West Point. So that's an old picture, but it's one of my favorites, so I keep it on my screen. So this is great. Thank you so much. Thanks for that kind introduction. And you will know the FTC standard. After I finish talking prior, you'll be very familiar with it, I think, and I hope. So I want to welcome everyone today. Thank you for coming. I do have slides, so I'll go through those. I cannot see on my laptop Q&A, so I'm going to depend on the host to let me know when there's a question. And I would ask everybody who is watching and or listening, if you have a question as I'm speaking, please feel free to post it. I get tired of hearing myself talk without any interaction, and especially so when I'm doing things virtually. And so it would be great for me to know where your heads are at as I'm talking about something, if I could address something more specifically or answer a question for you, any of those things. So I would encourage you to ask any questions that you have as I'm talking. So I'm going to go ahead and get started. The first thing I like to open with when I talk about this is sort of a little bit about myself. I'm a business attorney, and I work in the transactional field. So I do corporate, commercial, real estate, contracts, wills and trusts, and I represent small and medium-sized businesses sort of in their day-to-day activities. And cybersecurity is a part of what I do, and it's becoming a larger part of what I do. And so I often will have people ask me, why I'm talking about cybersecurity, what on earth, I would have to say about it that anyone would be interested in. I'll start by saying I'm not a tech person. So I like to say, you'll see through my presentation, I talk about the need to encrypt information, but I would not be the person you would come to find out how to do that. I would go to the experts and the technical people for that. So I don't have a technical background, but I do have a legal background, and I have a pretty long, sort of varied legal background. And the reason I'm talking about cybersecurity today, the reason I talk about it to just about anyone who will listen, I speak to a ton of local groups, I speak at national conferences, I speak at state conferences, I teach a cyber law and ethics class at a local college here in Tucson. So I do a lot of talking about cybersecurity. And the reason that I do is because it's part of my job as a lawyer to let my clients know what kind of risks they're facing, what kind of risks their businesses are facing, and to let individuals somewhat as well. But mainly my practice focuses on businesses or individuals in the business world. And what I found throughout the past, I would say 5 to 7 years, really since the Target breach, was cybersecurity, protection from data breaches, and now more so privacy, presents risks to business owners, to people who operate online or in the real world. There's a risk that they need to address. And my job as a lawyer is to help my clients address the risk. And the first step in doing that is to let them know that the risk is out there and what it is and what it requires of them and what they need to do. So that's really what started me talking about cybersecurity. You'll see that on the first slide, I have Target. That was sort of a groundbreaking moment from a legal perspective, because that was really the first time when the Target breach happened that courts concluded that businesses have a duty to protect consumers from criminal conduct of third party, consumers and banks, and are subject to claims for breaching that duty when it comes to cybersecurity specifically. And I threw banks in there because my background, before becoming a business attorney, I was an in-house attorney for a bank for years. And cybersecurity was always an issue within the bank because we issued credit cards and there were fraud issues and information security issues. But the losses were always on the banks. We were the party that bore any losses from data breaches, from fraud, from anything like that. We didn't like that as banks. We would have liked to have someone to sue who had contributed to the loss, but legally there wasn't any theory of liability for us to do that. And so Target changed that. Target opened up a new area of liability, the liability for a data breach, for someone's information getting into the wrong hands, even though a third party is the criminal, the hacker has gotten the information, the holder of the information, in this case, Target, could be held responsible for that third party's actions. So that was kind of a new and sort of groundbreaking area from my perspective, because I had seen so much in the bankruptcy not bankruptcy, in the banking area prior to that, that to see a change like that was really sort of interesting to me. So that really started me looking at it and thinking about it in terms of my clients, in terms of, even though I didn't represent Target, I had plenty of business clients who possessed information that their customers or their employees or their clients shared with them, and they held that information. All of a sudden, holding that information created a duty to protect it and to take steps to protect it. So that's what started me sort of out there talking about this from a lawyer's perspective. And it's really just grown and expanded since then. And recently with GDPR and the California statute, it even goes beyond data breaches and goes to privacy and businesses' obligation to protect their customers' privacy, if their customers are EU citizens or if their customers are California residents. Now there are all these new legal obligations on companies to honor those rights of the EU residents or of California residents, and other states that have adopted them. So it's really expanded beyond that. So the next thing, sort of the current climate in the data security world, and this has been true for years, it's just gotten broader, is the concept that the risk of loss extends to almost everyone who does business. I know when I used to talk about cybersecurity to business owners, I would always have a few people in the audience who would say, I don't have to worry about that. I'm not a tech company. I don't do anything. This is all silly. You're just, making mountains out of molehills. Then I would ask them, do you have employees? Do you keep their information online? Do you accept credit cards? And those are two things that most businesses do. So even just doing that at a minimal level yanks you into the obligation to protect it and the exposure if you don't. I will say I don't have many people who say that to me anymore in terms of recognizing that they have exposure, that they're operating in a world where that exposure exists. So in terms of other things that are happening in the current climate, I say here, others' cost of doing business are now your cost of doing business. And what I mean by that is really what I talked about in the banking industry. It used to be all on banks. It's not anymore. It used to be a cost of doing business for them. It's not just a cost of doing business for them anymore. It's cost of doing business for everybody. And there's an effort to spread it around. Is there a question? No? Okay. And then as I've seen, and this continues, as I mentioned, with privacy, exposure and liability are expanding and not contracting, and all behavior subject to scrutiny. It's really going to be, as the holder of information, what did you do to keep it safe? And if there's a data breach, your lawyer is going to have to defend you and is going to have to argue that you acted reasonably. And that's the FTC standard that I'll talk about in a little bit. But an example that I see coming up more and more often of the expanded responsibility and the expanded liability is that you can be held responsible for privacy violations or data breaches that occur as a result of your vendor's unreasonable practices. So even if you weren't the party that was unreasonable, you shared this information with a vendor, and that vendor has a breach, or that vendor violates a privacy statute, you can still be held responsible. And the reasoning behind that is twofold. Number one, what applies to you specifically as part of handling information reasonably is dealing with vendors who do the same thing, not dealing with fly-by-night companies that you have no idea whether they're careful with information or whether they're not careful with information. So that's where your behavior comes in that situation. And then the second part of it is the view that when a person, when a customer, when a client, when an employee has shared information with you, you have that obligation with respect to that information to protect it, whether you keep it or share it with a vendor. The obligation doesn't go away because the person, the consumer, the customer, the client, the employee shared it with you. So by sharing it with a vendor, whether it's a payroll processor for your employees, any third party, you still retain that obligation. So that's a perfect example of extended liability and broader liability within the data breach arena that didn't exist 7 or 8 years ago. It just didn't. Now it's pretty standard to hold that. So I like to talk about, one of the things I do as an attorney and as a business attorney for my clients is give them suggestions as to how to address the risk, how to reduce it. And so in the area of liability for vendors actions, there are things that you can do to protect yourself. And so these are the types of things that you can do. You want to make sure that any vendor that you deal with, that you're sharing information with, has the same or better data security standards as what you have. Now, that's assuming that your standards are good. I'm assuming that everybody follows best practices on every level. So you want to make sure your vendors do. You want to understand how they handle and store information. When it comes to your contracts with your vendors, you want to require them to set say in the contract, this is what we do to protect information. These are the steps that we take. You want to do that at the beginning of the relationship and probably periodically throughout it to make sure that they continue to do that. You can also, I recommend that my clients include indemnification clauses in their vendor contracts so that if there is a breach or if there is a privacy violation and you at your company is held liable for it, then you have a cause of action against the vendor. You can say, I suffered that loss, I paid that money, but you owe me that money because it was your fault. So that's the indemnification. The vendor would indemnify you for any losses that you suffer. Some other things, suggestions that I like to make require the vendor to certify that it has cyber insurance. You can even talk to the vendor, talk to their insurance company about being a listed insured, an additional insured on their policy, so that if there's an event, the coverage will kick in immediately. And I also talk to people who are vendors, and the advice that I give them is, if you're a vendor, you should keep these expectations in mind when you're dealing with a potential customer or a potential customer. You can expect them to be asking you about these things and to require these things of you. And when somebody is deciding whether or not to use a vendor, and you have two vendors who for all intents and purposes are equal, if one has better security standards, data privacy and protection standards, has cyber insurance, has all of those things, they're more appealing, to the customer who's shopping for a vendor. So you as a vendor want to do those sorts of things to make yourself appealing. And it really, at this point, I see it more and more, having those practices as a marketing tool, for businesses to let people know, to let other companies know, you can be comfortable dealing with me and you can be comfortable sharing information with me because I take protection seriously and I take steps to do it. And that makes you appealing to deal with. And, it's gotten to the point now with a lot of big organizations, the US government, the military, big companies, they require these sorts of things from their vendors. So you don't even have a choice. If you want to be a vendor and do business with this mega corporation or with the government, you may very well have a list of cybersecurity standards that you have to comply with to even be considered. So from a marketing perspective, it can only help your business. The next thing I talk about is the commercially reasonable standard. And that's the FTC standard. That's what they apply when they're looking at data security, when they're looking at cybersecurity, and when they're looking at companies to determine whether they should be held liable for practices that aren't up to par or a data breach that has occurred. And still now in the data breach arena, the FTC has sort of taken over the regulatory side of it. They're the ones who look at companies' behavior and make determinations. We don't have any separate agency that stepped into it. We have courts, but they'll really apply the same standard as the FTC. That's what they'll look at. And so that's why the commercially reasonable standard is so important. Unfortunately, I have to tell you, as I mentioned in the beginning, I've been a lawyer for years and years and years, have gone to law school, taken bar exams in several states. And if you ask me to define commercially reasonable, I would not be able to do that. The reason that I would not be able to do that is reasonable in the legal profession is what one of my law professors used to like to call a legal weasel word, which meant you could define it any way you wanted, depending on the circumstances. I don't completely agree with that, but what the word reasonable means is completely dependent on the circumstances. The question is always, in any situation, because this is a negligence, usually it's a negligence determination that you're looking at for data breaches. The question is always, what would a reasonable person do? Would a reasonable person drink and drive? Well, no, of course not. It's not reasonable to take that kind of risk. So when you have, a car accident that results from that, there's a determination that they didn't act reasonably. The same is true in the data breach area and the privacy area. what's reasonable for a company to do, what's a reasonable way for them to handle information. And that's going to depend on the circumstances. And the FTC did provide a little wiggle room with the word commercially. That gives whoever's analyzing the question, whether it's the FTC or whether it's a court, an opportunity to look at the surrounding circumstances when they make the determination and look at things like, what kind of information is this? What kind of company is this? How do they handle it? What have they said about it? All of those things come into play in determining what's commercially reasonable. In practice, what it tends to be and what you can keep in mind when analyzing that issue is best practices. You know, what are the best practices in the tech industry that you do with information and how you handle information. And there are standards all over the place. There are PCI DSS standards. Every organization has standards. There are, you know, just generally accepted best practices. Some of them are very complicated and far more complicated than I would understand with my tech background and training. Some are really simple, like have a password strategy. You know, don't use 123. Don't use the factory installed passwords, things like that. So there's a range, but it's usually what's the best practice. And the thing that I like to point out about the commercially reasonable standard and that concept in the data breach area, which is not always true in every legal area, but it is here, it's relevant, you know, from several perspectives and at several times. And its relevancy before a data breach is, you know, best practices. They're best practices because they protect information. So if you engage in them, not only are you getting a basis for your lawyer to argue that you acted reasonably in the event there's a problem, you're also getting the protection that they provide, that these best security practices provide. So before and during a data breach, if you're engaging in these practices, you're getting a benefit from them, a security benefit, in addition to the legal benefit that would come into play if something happened and you had to defend yourself. And then if there is a data breach and after a data breach, the best practices and the concept of best practices and the concept of commercially reasonable actions will come in the area of cyber insurance. Because what I've seen from an insurance perspective is typically insurance that write cyber coverage are going to want to make sure that you engage in those best practices. When they're insuring this risk, they have to determine, are you a good risk or are you a horrible risk? Well, how are they going to determine that in the cybersecurity area? They're going to look at the practices that you follow. So if you look at a cyber insurance policy application, the questions that they ask you are the best practice questions. What's your password strategy? What do you encrypt? How do you handle this? What do you do with that? So it ties into that as well. So really the concept crosses everything. It's not just the simple legal theory of commercially reasonable. It's how do you protect data, and that affects almost everything that you do in that arena. So just to give you some examples of things that the FTC of course has not come out and said, here's our list of best practices. You know, we're going to make it easy for you. Do this and you're good to go. They don't do that. Courts don't do that kind of thing. But what we can do is look at decisions that the FTC has made where they've said this wasn't a best practice. This was unreasonable. What we can take from that is if you engage in this, it's probably reasonable. So the FTC has looked at companies, and if they didn't prevent access to a network or restrict access to a network to those with a need to know, then that's been found to be unreasonable. That's not commercially reasonable. Not monitoring, your network to detect questionable activities or unauthorized users. That's not reasonable. So you can flip that and say, well, then it would be commercially reasonable to monitor your network to detect questionable activities or unauthorized users. Ignoring warning signs of issues with your network or security warnings. that's not a genius conclusion to come to, that it's reasonable to pay attention to warning signs. That seems very basic. If you don't do that, it's pretty clear it's going to be found to be unreasonable, and you're going to have a problem with that. Some of the others that the FTC and even courts have specifically talked about: not maintaining and using up-to-date antivirus software, or using systems to protect against malware. And I specifically read an opinion, I can't remember whether it was a court or the FTC, but a company had purchased the antivirus software, but they never updated it. They just ignored the updates, and then they had a problem. Well, it's not a big jump for the FTC or the court to say you should have updated it. You bought it and you used it, keep it effective. That's pretty clear that that's unreasonable not to do that. Violating industry standards that I talked about previously, PCI DSS, there are just a ton of them out there. Not having a written data breach response plan, and I find that in a lot of statutory. New York has a cybersecurity regulation. It's specifically in there. GDPR has a cybersecurity part of GDPR. It's specifically in there. So that's pretty standard to have that. And no employee training on data security is a big one. And I say that that's a big one because previously it had been just in the data security area, the cybersecurity area, that was talked about. But I notice, and I'll talk about this in a little while, in the California statute on privacy and consumer rights, they specifically require employee training, and they require certifications of that. So there's a recognition in the statutes that training your employees to understand what your obligations are is important enough that if you don't do it, you violated the statute. So that really is an easy way to look at whether something's commercially reasonable or commercially unreasonable. It's important enough that they're putting it in the statute. It's pretty clear that it's something that companies need to be doing to comply. So next up, just a little bit about cyber insurance. I could probably do a whole presentation just on that. I'm not going to do that today, but just to sort of the tips that I like to give people is, typically it's excluded from your general liability coverage, so you want to make sure that you have it, or at least investigate whether it's something that makes sense for you and that's affordable for you. The existence of cyber insurance doesn't eliminate the need to invest in cybersecurity. You don't get to say, well, I've got insurance, so I don't care. That they'll cover me, it doesn't matter. No, as I talked about, the insurance company is always looking for an excuse to deny coverage. If you don't engage in reasonable security practices, they're going to deny coverage. That's an easy one. So you still have to take steps to protect data. I talked about the link between cybersecurity and cyber insurance, and then understanding your coverage. There are lots of different ins and outs of it, what it covers, what it doesn't cover, when it covers it, when it doesn't. Courts have interpreted provisions. It's good to get educated in that when you're purchasing the coverage, so you know what you're paying for and you're getting what you need. I mean, that holds true with any coverage, but I think especially with cyber coverage, because it's still relatively new. People have it and people are getting it, but it's not like the typical coverages. CGL coverage has been around for years and years and years. And so you're pretty clear on what's standard and what's not. Cyber is new enough that there's still a lot of changes out there. So I recommend that people kind of, get a little bit educated on that, whether it's through their insurance agent or their attorney, who knows about this stuff, to sort of make sure that if you're going to pay for the coverage, you're actually getting coverage that's going to be useful and helpful to you. So the next part that I want to talk about, and I don't know, I'm going to look at my clock. I think I have 5 minutes left. Is that all? Okay. All right. So 10 minutes. I have 10 minutes left. Okay. And I don't have, and no questions. Okay. So what I'm going to do for the last 10 minutes then, I'm going to talk about cybersecurity and privacy regulation. And my slideshow, the rest of the slideshow, which I think is distributed to you all, goes into a lot more detail than I'm going to go into today, that I even should go into today. I think the important thing that I want everyone to know about cybersecurity and privacy regulation is sort of the viewpoint that it comes from, because it's a relatively new viewpoint. It's a relatively new perspective. And I think it's going to continue, and I think it's going to get stronger, and I think it's going to get broader as time goes on. And the reason that I say that is that starting with the GDPR, the EU came out with that regulation, and it applied to residents of the European Union. And so the purpose of the regulation, or the goal of the regulation, was to protect those residents, to protect their rights when it comes to information and when it comes to data. That was, at the time, a relatively new way to look at data, and a relatively different way to look at data and information and people's information. And it wasn't happening so much in the United States. I didn't see much of it at all. So when I talked about data breaches, I didn't talk much about privacy from that perspective. The privacy and data breaches was protecting information. And is the information the type that needs to be protected? Is it PII? Is it medical information? That's where the privacy came in. But the European Union regulation kind of switched things around. And the way that it did this was it looked at consumers and what were their rights, and what were their rights when it came to information. So it started with the GDPR. Again, the coverage of it was European Union citizens. So, that being said, I have clients in Tucson, Arizona, who are required to comply with GDPR. So even though it's European Union residents, it's broad enough. It was broad enough to encompass them, because if you advertise to them, if you provide services, if you invite them to partake of your services, you can get yanked into the regulation. But what really brought it even more to the United States and brought this view was the California regulation, the CCPR. And so the view reflected in that, and the GDPR and the CCPR is, as I said, the value of information and the idea that individuals possess that information. That's something that they have rights to. And when they share that information with you, they don't give up those rights. And you, as a company, are now obligated to honor those rights. And you're obligated to take certain steps with respect to information. That's very new, and that's a very different perspective than just protecting information from the bad guys and keeping it private and making sure nobody gets it. This is consumer, this is consumer rights. And when it comes to legislation, for legislators, it's pretty easy for them to pass consumer rights legislation. And they like to do it because it affects lots of people. And when they're up for re-election, or when they're up for election, they can say, look what I did for you. Look what I did for all of you consumers. I recognize that you needed this protection, and I helped pass a law that gave you this protection. So it's very appealing to legislators. It's very appealing to regulators. There are regulatory agencies whose job it is to protect consumers and to stand up for consumers. This is what's happening in the information security area. And so California, I like to describe it as, GDPR did a little bit of this, and then California said, oh, hold my beer, I'm going to do better. We're going to have an even broader statute. And so they did. But at their core, they really look at a consumer's right to information and a view that you as a business, you have certain obligations when that consumer shares the information with you. And we're going to statutorily require that you comply with those obligations. So we're going to tell you, you have to disclose how you handle information. You have to disclose what you do with it. You have to say whether you sell it. You have to give them an opportunity to press a button and say, don't you dare sell my information. You have to tell them what information you have. They can send a written request to you, and within 45 days, you need to get back to them and say, this is what we have. If they find a mistake in their information, you have to fix it. If they decide they don't want you to have your information anymore, you have to get rid of it. You have to delete it. They have a right to be forgotten. That's a specific right that California residents and European Union residents have, the right to be forgotten. And you as a company cannot deny them that right. You have to help them enforce that right. You have to allow them to enforce it. So it's a very different view. I've seen talk of, it hasn't happened, but I've seen and heard talk of it. I wouldn't be surprised to see it happen as we move forward with this. The idea of the value of information that a consumer shares with you, and you being responsible for that value, you having to pay them for the value that they confer on you. That could very easily flow from the legislation that we have and this view of information. And so at this point, it's California. California, it's California residents that are protected. It's a pretty wide swath of people, and companies who do business nationally have to be concerned about that and have to pay attention to that. But my recommendation to my clients about it is, whether or not you're covered by GDPR, whether or not you're covered by the CCPA, you eventually will be covered by legislation that requires something similar to this. I think at last read, there are 25 states that are thinking about legislation or that have it in different stages similar to this. It's eventually I believe, going to hit the whole country. Oh, are we done? I see red, 1 minute. Okay. So anyway, so that's it. So it looks like I'm going to get cut off. So before I get cut off, thank everyone so much. Hopefully it was worthwhile to listen to me chatter on today. And I hope you enjoy the rest of your conference. Thank you.
I love you.
Oh, I love you too. You're so sweet. Thank you.
I'll be in touch otherwise.
Okay,
Yeah.
great. All right. Take care. And if
bye.
anybody has any questions, you can pop them on and, I'll try to answer them as best I can.
Okay. Thank
All
you
right.
so much.
Take care. Thank you. Bye-bye.
Bye.